So let me get into the 5 most important things that you need to know if you own or carry a firearm in this state. Number 1, this I kind of summarize in 3 words, just shut up. Now, I'd love to move to number 2. It would save us a lot of time, because number 1's pretty simple, right? Anybody confused about number 1, the just shut up rule? I'd really love to move on. And the younger Marc Victor definitely would have moved on. But the older, wiser Marc Victor knows that some of you, maybe even most of you, still won't follow that rule. So I gotta fill in a little bit of detail, because I don't want you to come to my office after some type of criminal charge is brought against you and then hear that you gave some long statement, especially if you heard this talk. Fortunately, just at the right time that you need to be reminded about this advice, the police will remind you. It's called the Miranda Rule. Some of you have heard of it. Just in case you haven't, it comes with 4 pieces to it. First, the police officer is going to tell you, right at the time you need to hear, which is the time you're getting a new set of bracelets on your wrists, right? Everybody knows what that means. Right around the time you're to be arrested, police officer is generally going to tell you, you have a right to remain silent. It's a right. It's not a privilege. You have that right. But just in case that doesn't get the job done, the police officer will then tell you number 2. Number 2 really ought to get you thinking. Anything you say. Think about this. It deserves an extra second to break it down. Anything you say will be used. Who knows how it's going to be used? Anybody know how it's going to be used out there? Against you. Anything you say. And us criminal defense lawyers, we'd prefer that they modify that a little bit to say as follows. Anything you say, and some stuff you didn't even say, and some stuff you didn't even say will be used against you. Now, I'm not speculating about this. I'm telling you about my experience from real cases. Sure, lots of clients come in and say, I never said that, but I've had cases where the statement was recorded. And still, the police officer in the police report, in quotations, reflected something that the person purportedly said, but actually didn't say. Incidentally, when those kinds of statements come up, who thinks that those statements are helpful to the defense? That those statements will help you? Nobody. I can tell you in 100% of the cases, those statements are the worst statements in the case. Also, the third thing, you have a right to an attorney, which they should put a little addendum on, but not right this second. And fourth, if you can't afford one will be provided to you for free. That's called a public defender. Those are the 4 warnings that make up the Miranda warnings. Contrary to public perception, they don't have to actually tell you word for word the same things, although they usually do, because they read from the back of their department-issued Miranda card. I tried that a few times as a young lawyer as I was fishing around for some information during a police interview, and I would say, did you read the Miranda warnings? Yes. Did you read all 4 of them? Yes. How can you be sure you read all 4? They pull out the department issue card and they tell me they always read from the back of the card to deal with pesky defense attorneys like me. So, on the back of my card, if you have it, and I think it's going to be in your materials there, this gave me a great idea, right? So I drafted up what I think you should say, assuming you can't follow the just shut up rule. It's perfectly fine to say exactly this. So if you carry my card with you and you find yourself getting ready to have a new pair of bracelets, you could just simply read this or memorize it, and then it's very clear what you said to the police officer at that time. Any questions about that? Some people still speak. Question?
As I understand it, you're required to identify yourself.
Question is, as I understand it, you're required to identify yourself. Sort of an interesting question. This is an area of the law that is in a slightly gray area, but I can tell you what Arizona law says. Certainly, as everybody knows, if you're driving a motor vehicle and you get pulled over, you have to produce your driver's license. We all know that, right? Arizona has another statute that says if you are detained with reasonable suspicion, if it's a lawful detention, then the officer has a right to demand that you provide your true full name. That's all it says. You got to give your true full name. And so we're jumping ahead a little bit because this gets to one of my exceptions to the just shut up rule. But it's true, if you're detained by a police officer, it doesn't say you got to provide anything unless you're driving in a car, right? Then you got to give your license. But if you're walking down the street and a police officer says, "Excuse me, hold on, I want to ask you some questions. What's your name?" You have to give your true full name. And it's a crime not to. There's a little section in there that specifically says, by the way, that the officer is supposed to advise you before and say, look, if you don't give me your name, you could be charged with a criminal offense. If they don't do that, then this is sort of an escape from the prosecution. But that's the rule in Arizona. So I don't think that there's really any downside, frankly, from giving your name. Because if you don't, they're going to take you in and they're going to fingerprint you anyway and figure out who you are. I actually had a client one time who did that. He refused to give his name. They were going to cite and release the guy, but because he didn't give his name and he wouldn't accept service, they arrested him. They brought him in front of the judge, and the judge said, "What's your name?" And he said, "I'm not saying anything." And then they fingerprinted him, and he stayed overnight, and eventually they figured out who he was. So I don't necessarily recommend that course of action unless you just want a tour of the jail or the local justice system. So I want to remind you of some important things that maybe some of you don't know. But the fact that you remain silent, that can't be used against you. You should know this, because a lot of people speak thinking that, well, if I don't say something, I'm going to be arrested, or if my case goes to trial, then I'll be asked about that if I take the stand. Hey, if you're really not guilty, why didn't you speak when the officer said what happened? I'm just here to let you know that's not the way it works. A jury in a criminal case doesn't even get to hear that the officer asked you what happened and then you said, "I want my lawyer, I got nothing to say." It doesn't even come up. And if it does come up, assuming the defense attorney is not sleeping at the switch, the defense attorney will say, "Excuse me, Judge, can we approach?" And then we'll go up to the sidebar. You ever wonder what happens at the sidebar when we go up there? And now in the fancy courtrooms, they press a button and there's all this white noise so nobody can hear. But generally what happens up there is the defense attorney will say, "Hey, Judge, that police officer just commented on my client's constitutional right to remain silent." This is usually the time where the prosecutor will say, "Well, no, he didn't quite say that," but we'll get into some type of an argument. And generally speaking, if the judge finds that's what happened, now we're talking about whether there ought to be a mistrial and we start over again, or whether the judge just simply instructs the jury to disregard that. But what I'm trying to get to here is that not only do you have a right to remain silent, but the further step that a jury doesn't get to draw any negative inference against you because you remain silent. The only way to accomplish that is to keep the jury from hearing the fact that you chose to remain silent. It's also not a reason for the police to arrest you. They don't get to say, "Hey, the guy wouldn't tell me what happened, so I get to arrest him." They get to arrest you if they have probable cause to believe that you committed a criminal offense. Then they can arrest you. If you don't say anything, that doesn't give them extra weight on the side of the scale to determine that they have probable cause to believe you actually committed a crime. The other reason I don't like people to speak, and I alluded to this right at the beginning, some organizations and some other criminal defense lawyers give my opinion, much too general advice. And this is specific to after a shooting, to say, "Hey, look, I was in fear for my life." I don't recommend you say that. Because if you say that, it better be the case. Because you're stuck with that statement. And there might be other reasons, other legitimate reasons meaning reasons why you get a not guilty at trial and get to go home, those kind of reasons why you might have shot and killed another human being. Like, for example, maybe you shot and killed that person to protect a third party, somebody besides you. Well, you can do that in Arizona under certain circumstances, the usual circumstances. But if you opened your big mouth and followed somebody's much too general advice to say, hey, I shot because I was in fear for my life, you are stuck with that. That's your defense. And we're moving forward on the case with that defense, even if it turns out that the other person got shot in the back. That's going to be a little bit of a problem for our defense. Does everybody see that? And I haven't even talked yet about 13411, a completely different reason called the crime prevention statute, that you can shoot and kill another person that has nothing to do with you being in fear for your life. It's much better to just not say anything. What I'm really saying here, on behalf of criminal defense lawyers across the United States, make our jobs easy. You don't want us to have to work too hard to represent you. If you keep your big mouth shut, that really helps us a lot in most cases. Plus, another reason to keep your big mouth shut, in all cases, but especially after a shooting, I can tell you this as somebody who has spoken to many people after a shooting. This isn't a good time for you to be making a statement. You're in no condition to be making a very detailed statement that's going to be written down and recorded and used against you. If you just shot somebody, especially if you killed that person, your hand is probably going to be going like this for a while. You're going to be freaked out. Your mind is going to be replaying this event over and over and over again. And this is exactly the time police officers like to get in there and get a quick statement from you. But you may be leaving out important details. You may not be lying about anything or trying to make anything up. But what if you just forgot something? What if that something is really important? You know, a year or 2 years later, when your case goes to trial, and you say on the stand, this is what happened, and then the prosecutor says, well, isn't that interesting? At the time of, right after the shooting, when the officer asked you what happened, and you didn't follow Marc Victor's advice to keep your big mouth shut, you gave a statement that didn't include that information. Do you have a better memory now than you had at the time? You're going to be stuck with that. You don't want to be stuck with that. I hope I've convinced you to keep your big mouth shut. But in the off chance I still haven't, I got more. Now, I know some of you might think police officers are perfect. I'm here to tell you, just like everybody else, they got good and they got bad. Now, to be fair about it, and I'm speaking to you as a freedom guy, somebody who thinks there's way too many laws and probably way too many police. I'm telling you, I think we got more good cops than bad cops. I think we have far more good cops than bad cops. That's what most criminal defense lawyers, I believe, will say. But all that notwithstanding, some of them are incompetent. And when you make a statement to a police officer, you got no guarantee that that officer, who's even trying to act in good faith, is writing down your statement accurately. What if they just get it wrong? And what if that wrong statement really hurts you? I've seen this before in criminal cases. Do you really want to trust potentially decades of your life to the accuracy of a police officer who's writing things down? This is the negligent police officer, right? Just not doing a good job. Lots of times they're out there in the field and they're writing little notes down, and maybe they just misinterpreted their notes when they got back to the station. They didn't understand something, they filled something in and it's really not what you said. That can happen. Then, we can talk here, right? I mean, this is the Crossroads of the West Gunshot. I don't need to pull any punches with you. Some cops are just lying criminals. We have cops in prison in this state, and that's exactly where they belong. And if you don't know who you're dealing with, and you probably don't, do you really want to take a chance on a police officer that you don't know about, maybe that police officer is one of the minority of crooked police officers. And some of those police officers don't like the fact that non-police officers carry guns. I've had police officers tell me that before. Again, do you want to make a statement with this kind of a police officer? I can tell you I don't. And you don't know who you're dealing with. I'm saying, I like my freedom. I'm guessing you like your freedom. Keep your big mouth shut.